Welcome back. I'm talking to you today about Tom Keesee and David Taylor. So if you've been watching me, you know I've been following the Tom Keesee trial, upcoming trial. It's not reached trial yet, but he was charged back in April of 2025 with approximately 32 felonies by the state of Ohio. And he is scheduled for a jury trial on November 18, 2025. That's about a month away. So there's been no movement really on the docket. Nothing's happening as far as motions filed. Nothing in regard to any indication that this is not going to go to trial. I've talked about this before, that his options are going to trial or taking a plea deal, but I don't have any inside information to know whether a plea deal has even been offered to Tom Keesee. As you may recall, he has 4 victims. One of them is his own sister, and all of these victims were abused. The allegation is that they were all each abused at a very tender age before they were 13 years old. So that's the evidence. Those are the 4 witnesses that are coming forward at the jury trial in about a month. And there are going to be other witnesses as well. Obviously, the detectives that investigated, and there's going to be civilian witnesses as well. And I've talked about this before on this channel. There are some witnesses that have said, they have alleged that Tom Keesee has admitted to him, at least in part, to some of the acts that comprise the crimes that he's been charged with. So we've talked about this before, and in the context because recently we just saw what happened to Robert Morris, who did not go to prison, folks. He did not go to prison. That continues to be spread around, but it's jail. He went to jail. Now, the good thing about that sentence is that he has a 10-year sentence. Now, 9.5 years of it is probation right now. 6 months right now is in jail. Now, why do I say right now? Because he has oversight for 10 years. That means that if he violates any condition of probation after he gets out of jail, guess where he could be going? Prison for up to 10 years. And I think that people don't realize that. You know, a lot of people are like, why did this happen? The judge. No, this has nothing to do with the judge. This was a plea agreement that Robert Morris made through his attorney with the AG's office with the consent of Cindy Clemenshire. That's what happened. So let's take that over into the context of Tom Keesee. Could that happen there? Yeah, it could. I believe that what the state will have to do is they'll have to get with each of the victims, if that's the case, and make sure that they're all on board. I don't know if that's even something that's in the works, but it could be. And if that happens, it could be before the jury trial date, which is November 18th. Now, what happens on that day if there's no plea? Well, they pick a jury. That's called the voir dire process. Both attorneys, the defense attorney, the prosecutor, they will pick a jury. It could take a couple hours. It could take a day. It could take 2 days. The question will be, one of the first questions, obviously, is going to be whether those potential jurors know anybody associated with the case, that are involved with the case, any of the detectives, any of the victims, any of the witnesses, any of the attorneys, the judge. Have they heard about any of the allegations? Did they ever go to Faith Life Church? Do they know Gary and Brenda Keesee? Are they familiar with anything? Do they watch YouTube? Do they get on social media? Do they have any knowledge? But most importantly, have they made an opinion one way or the other? That is what's going to be asked of them, because they can hear about it all day long and still be a juror. The key question is whether they're biased. Have they already formed an opinion that would not allow them to be open to hear both sides and apply the facts to the law that the judge gives them? That's going to be the question for that panel. Now, once the jury is picked, the parties will do their opening statements. The state goes first, then the defense attorney, and then the state will put on their case in chief. They put on their witnesses. They can do it in any order they want. It could be, the investigating officers. It could be a detective. It could be a witness that's not a victim. It could be the victim. but they have several to choose from. I think there's about 10, 11 witnesses at least. They also have an expert, a psychiatrist, no, a psychologist, not a psychiatrist. And based upon what I researched, this was back months ago when I first saw that she was listed as a witness. I shared this in a video. I anticipate that she's going to be utilized as an expert just to talk about the victimology, especially with sex crimes. When I looked her up, she has a background in sex crimes. So that's what I anticipate is going to be addressed with her. And, also just how victims disclose, it's delayed sometimes. In this case with Tom Keesee, yeah, it was delayed as far as it getting to the criminal process, but I don't think it was delayed. There was mention of this to family members, to other people, and the allegations are that Gary and Brenda Keesee knew about it as well. So if that's the case and that's proven, well, then it really wasn't delayed. So it just wasn't brought to the attention of the authorities, is my understanding of what the assertion is going to be. But I will be up there for that trial. At least I plan on being up there so long as it goes to trial. And I will be reporting on it. So if you can't make it up there, because this isn't something that's going to be covered by Court TV. So I plan on being up there, being in the courtroom, and during the breaks, I will do updates so that you know who's saying what, who's on the stand, what the arguments are, any information that I can share, I will be doing that. And that's in a month from now. Now, before I get into David Taylor and this 48-page document that just came out today, I want to remind you all about the podcasters event that's this coming Saturday. It's in Atlanta. And if you can't make it, that's fine. There is going to be a link that you can use if you want to get the live stream. It's about $20, I believe. So I'll have that link. It's the same Eventbrite link that I've used before. And it's now going to allow you to choose that option to purchase that live stream. And then once your email's in there, I believe that's how it's going to work, then you'll be notified on how to get that link and you'll be able to get that live stream. So if you can't join us live, then you'll be able to join us by live stream. And it is going to be, we're all really, really excited. And who's going to be there? Well, Pastor John T. Have you ever heard of Pastor John T? He's going to be there. Pastor Ray Curry is going to be there. Laura Lynn Tyler Thompson, Elizabeth Davis, Lynn from Gospel of Narc, Everett from Ohio for Freedom. Who am I missing? I think that's it. Am I missing anybody? I always miss somebody. All right. So we're all going to be there and we are all looking forward to it. It's going to be a good time. All right. Let's get into David Taylor. Now, as I said, this is a lengthy document. What is it? It is a memo that was filed by the United States government in support of detention for David E. Taylor. Remember, I did this a couple of weeks ago with Michelle Brannon. She got a $10,000 bond. Now, a lot of the information in this is repetitive. I mean, it was also in the memo that they filed against Michelle. So what I'm going to try to do, and I highlighted portions, but I'm going to try to just focus on the evidence that they're putting in here, that they're laying out specifically against David. If this is new to you, please go back to the other video because I don't want to be redundant. I want to be, I'm trying to be concise as possible. We're focusing on David Taylor today. Remember, they were both arrested. He and Michelle were arrested on August 27th. And now we're into the middle part of October and he still hasn't been brought to arraignment, which is odd. Now, as you guys remember, Michelle had some medical issues that likely disrupted getting her to the Eastern District of Michigan timely. Well, I don't know. This is my opinion. You'll hear me say that throughout this motion as well, probably. My opinion is probably something similar happened to him, where he may have had some type of medical issue that thwarted his ability to be transported to the Eastern District for this arraignment. So again, the same thing like they asserted with Michelle Brannon, they are seeking detention, pre-trial detention. They do not want bond. That's what the government is arguing. Obviously, his attorney, and as you know, I've said it before, he has an attorney that's in St. Louis. I would expect that his attorney is going to be there live, just as Michelle's attorney was live, also from St. Louis, but two different attorneys. David Taylor's attorney is, his last name is Rosenblum. I can't remember his first name. I think it's Scott, but I'm not quite sure. Now, the government is saying that David Taylor is a serious risk, that he will flee and attempt to intimidate witnesses and victims. And then throughout, that's their statement. That's what they're saying to the court. He's a serious risk. He will flee, a flight risk, and he will attempt to intimidate victims and witnesses. So that's what they're asserting. And of course, his attorney is going to say, oh, no, just like similar to Michelle Brannon, that no, he should get a bond. Now, talk about similar to Michelle Brannon, this next part. Do you remember this in her memo where they said that she lied to pretrial services? Well, here we go. It says Taylor lied to pretrial services in the Middle District of North Carolina when the pretrial services officer asked him where he resides. Now, this would have been at his arrest because he was in North Carolina. Instead of identifying the address in Durham, he said he lived in St. Louis, Missouri for 17 years. Well, that was a lie, they found out, because he was living in Durham. Interestingly, Taylor requested a detention hearing in the Eastern District of Michigan on August 27th. Ooh, this is a typo. It says August 27th, 2005. It should have been 2025. So that's a typo. So that's interesting, because if he requested that, then what was the holdup? So if you don't know, they will record this, but I won't be able to get to the recording until after I get back from my trip to Atlanta. And I'll listen to it and I'll let you know what they say, because I want to know what the delay was, and I'm sure you do too. So sorry that you can hear my mouse, but I have to move this down. Okay. So in this one, it says that the victims in counts 2 through 7 of the indictment were full-time laborers, and in counts 8 and 9, they worked as armor bearers. And that would be indicative of specifically to David Taylor, because he's the one that had the armor bearers. So 2 of those victims in that indictment were his armor bearers. And I know I've shared this before. I do talk to people. A lot of stuff I can't share, but I do know of one of those armor bearers. So until this goes to trial, and after that, I intend on, hopefully getting the opportunity to speak to this individual on camera so that we can talk about things. Okay, so now it says, since approximately 2020, Taylor has not been living at any of the call centers. So Taylor began exclusively using cell phones to communicate with the workers. Taylor instructed and entrusted Brannon to carry out his orders and punishments for the workers. Taylor and Brannon frequently communicated their orders and punishments via text messages. We saw that before, but in this one, there's way more text messages starting in May of 2021. And there's 1, 2, 5, 6, 7, 8, 9, 10, 11, 12. So there's 12 of them that are outlined here. And they go until July of 2022. And it's about, throwing water on their face, top closers, go in the garage, take away their food. It's all of that stuff, not going back into it, okay? They talk about all of this forced labor scheme that grosses them $50 million since 2014, just to recap. They also talk about what they got back from the execution of the search warrant. And some of that, I talked about that when I was reviewing the memo for detainment in regard to Michelle. It's the same stuff, and it's going through all of this stuff. So let's go past that. They also talk about this. There's a sexual element, and I talked about that in Michelle's as well. But I don't think that that really had any. This is my opinion, not reading from this. This is my opinion. I don't think that that had any relevance to the judge because the sexual nature, remember the videos, the photos. I talked about that, and perhaps the judge wasn't moved by it as it related to Michelle because it wasn't Michelle. It was Taylor who was alleged to have done that, to have coerced some female workers into providing sexually explicit photographs and activities in videos and photos. And in here it says that these female members who have disclosed these things, they are fearful. They were fearful of disobeying him, and they had no choice but to send him what he demanded. Now, remember, the judge just couldn't understand that aspect. Like, why couldn't they leave? Why couldn't they just not do? You have to understand cults to understand that psychological aspect. I mean, throughout this memo, and even in the one before, it spells out how they were fearful, why they were fearful. Why can't I say that word? And they spell it out. And it's not just about physical abuse, it's about psychological abuse as well. It's the threats. And in my opinion, this is my opinion, I thought that they did an excellent job, that the government did an excellent job in outlining it. But unfortunately, it wasn't enough for the judge. And remember, he let Michelle Brandon have a $10,000 bond. So now, what's going to happen here? And when is it? Did I say it? Did I even say it? Well, probably not. David Taylor's arraignment is this Friday. It's on October 17th. So this memo was filed today, 3 days before. Today's Tuesday. Yes. So 3 days before. What we might see is a response filed by his attorney. And it's going to be similar to what Michelle's attorney did too, that not a flight risk, that they didn't meet their burden, that the government didn't do what they needed to do. Remember, in the Michelle Brennan detention hearing, the judge was, and it's going to be the same judge, he was asking the government, well, where's the evidence of harm? Where's the medical records? Well, that doesn't always exist. These people were in fear. Doesn't mean that they were necessarily harmed. Now, there are allegations that they were actually physically abused as well. But it's clear most of it was a psychological nature. There's not going to be medical records, especially if they're fearful that they can't leave, then they're not going to be going to the hospital. All right. So again, they say that there's a serious risk that he will flee and attempt to intimidate. And they just go through this. And I'm going to get to, let me just go down to the conclusion. Well, before I get to that, they do talk about the lengthy term of imprisonment because there's the argument that he's going to be motivated to flee because he doesn't want to reap those consequences of a lengthy imprisonment sentence, which will be in a federal prison. So they talk about, the high quotas, all of that stuff, what they did, victimizing, things like that, the lengthy sentence. They talk about here also the harm forced labor victims fear is often physical abuse. However, fear caused by psychological abuse is often more powerful than the fear of physical harm, which a victim can be free of once the defendant is no longer physically present and able to personally inflict that physical harm. The purposeful psychological climate of fear Taylor created and enforced by his orders and actions on a daily basis for over a decade does not simply evaporate when he is physically removed from his victims. So that what they're saying is, yes, he's in custody, he's out of that cult, and victims, either they're in the cult or out of the cult or whatever, and they're saying that that sense of fear remains with the victims. It says, The fear persists in the legitimately traumatized minds of his victims. This capacity of a defendant to continue to inflict psychological, reputational, financial harm, among others, type of harm, among others, I think it should have said other types of harm, yeah, encompassed by the statute, even at a distance, is recognized by Congress. This is exactly the kind of danger Taylor poses, making the weight of his dangerous to the community strong. In addition, the charged offenses, 10 separate counts, each carry a statutory maximum of 20 years in prison. So now they go through this, and I didn't see it in the other. They talk about these levels that they are designated with the forced labor. So they say that the base offense level for forced labor is 22 under the statute, but with likely applicable enhancements, that the government's initial estimated calculation of Taylor's offense level as of today's date is 34, which corresponds to a sentence range of 151 to 188 months in prison, which is 12.5 to 15 years. So that's a lengthy sentence. Saying that he has a strong incentive to flee to avoid a lengthy sentence. And they talk about him personally. He's 52 years old, unmarried, has 2 adult children, no employment outside the criminal enterprise. And that's exactly what was asserted by the government in regard to Michelle. Here they also point out that he, Taylor, does not have significant family or community ties to the Eastern District of Michigan. I believe that Michelle had her son there. So they talk about the lack of ties. His activity is solely with this criminal activity associated with the alleged ministry in the states of Michigan, North Carolina, Texas, Missouri, and Florida for at least 5 years. Again, noting that he's been living in Durham and not in St. Louis, as he told pretrial services following his arrest. They talk about that he does not have any prior criminal convictions. Well, he doesn't. You know, if you've been researching this or following any commentary on this, people say that he does. He does not. He does not have any criminal convictions. People refer to depositions that they saw him testifying in that had nothing to do with him as far as a party. He was a witness. He was subpoenaed to testify. He was also represented by an attorney there, but he didn't have to, but he did. It was a party. It was a divorce proceeding against 2 parties not related to him or his divorce. It had nothing, there was no criminal nature to it. So, although Taylor does not have any criminal prior convictions, he has been engaging in a continuous course of criminal conduct that has terrified his victims for the last 12 years. In addition to his lack of legitimate ties to the Eastern District of Michigan, the government's financial investigation, which remains ongoing, they say, established that he has access to numerous sources of funds to flee. First of all, even though he doesn't have access anymore to the KOGGC funds that the government seized at the time of his arrest, they assert that KOGGC continues to actively solicit donations to support Taylor and Brandon and will likely make those funds available to him. Also, he has access to financial platforms that allow individuals and businesses to send and receive money both domestically and internationally, including PayPal, which is an online payment system. Third, he has 2 life insurance policies. He would be able to obtain approximately $150,000 with one of them. The other one is just under $50,000. Fourth, he has access to multiple credit cards, but the ones that they listed, I mean, the credit line was only 4,600 on one and 2,000 on another. So it's not like he's going to get very far with those. All right, so let's go down. I think we should be at. Yeah, they talk about, okay, and then the coercion of the women in his criminal organization to provide him sexually explicit videos and pictures. His sexual predation, preying on people, makes him a danger to the community for several reasons. And they talk about that, the sexual nature of that. They go into that, being addictive and being a danger. And then, due to the nature of his victimization that occurs to women who are coerced to provide the explicit material, that these victims will remain fearful that he, Taylor, or someone in his direction will distribute that material. And that's a legitimate concern. They also state he's a danger to the community because his teachings during the conspiracies included encouraging self-inflicted violence and violence against others, including law enforcement, when and if his organization is confronted by law enforcement. Significantly, he, Taylor, attempted to convince the workers to commit acts of violence against themselves or others, and that Taylor has made promises to punish and get rid of those who do not serve him. I talked about this before. He identified the Michigan Attorney General's office and stating that God would kill officials, like I told you, referring to the FBI, all of that stuff, all of those threats, which I'm surprised that terroristic threatening wasn't charged in here, but all right. So they say, lastly, Taylor continues to have supporters. Yes, he does. I've seen them on my channel. I have had to block them. They are insane. He does. He has supporters. They are out there. They are active, and they harass people like me. So lastly, Taylor continues to have supporters despite his arrest who have and who likely will continue to assist him in intimidating current and former members of KOGGC. Yes, I can imagine. They like to harass and intimidate people that they don't even know that talk about this. So I can just imagine what they're doing to people that were former members of their cult. More recently, one current member of Taylor's organization interfered with victims and witnesses who sought to accept victim services from victim witness personnel and nonprofit organizations following the execution of the search warrant in Tampa on August 27, 2025. Taylor specifically has threatened and harassed members who indicated that they wanted to leave or were able to escape. Taylor told the member that they would die or get cancer or go to hell, and that their family would be cursed. In addition, Taylor has told members that he knows people in law enforcement, including the FBI, who will come after them if they leave the ministry. Members who have left report receiving numerous threatening and harassing messages from members through text and social media. Right. So this is what they assert. And we are going to find out on Friday, October 17th, what happens at that bond hearing. I do plan on getting information in regard to what his bond is, and I will do a quick update from Atlanta in that regard. And I anticipate that sometime the week after I go through the recording on the specifics of what was said during that hearing, I will do a video on that. But you'll also probably see videos from me and my other fellow podcasters throughout the weekend about the events that are going on. And we're going to be collaborating and doing videos over the weekend. So stay tuned for that. So I hope that this helps give you an update, and we'll see what happens on Friday, and we'll see you then. All right. Talk to you soon. And check out that link. I'll have it in here if you want to get that live stream for this weekend in Atlanta. See you soon.